Welcome to The Explainer. Today, we're diving into a high-stakes legal battle over a single brand name that went all the way to the Supreme Court. You could call it a David versus Goliath story, but who you see as the underdog, well, that really depends on your perspective. So, at the very heart of this case, you have two companies with names that are pretty much identical. On one side, you've got the established international trademark Paperone, two words, and on the other, a Philippine company registered as Paperone Inc., one word. And that tiny difference sparked a years-long fight over who actually had the right to use the name. So let's set the stage and meet the players in this branding dispute and figure out what each side was actually claiming. Okay, so the petitioner, Asia Pacific Resources, basically argued that Paperone Inc. was unfairly piggybacking on their brand's hard-earned goodwill. But Paperone Inc. fired back, saying, hey, our corporate name was legally approved by the government. They also made the point that they weren't even selling the exact same products. They were in the paper conversion business, making things like notebooks and napkins. As you can imagine, this disagreement sent the case on a wild journey through the court system, with completely different outcomes at each stop. It was a real legal roller coaster. So first up, the Intellectual Property Office found Paperone Inc. guilty. Case closed, right? Nope. In a pretty dramatic reversal, the Court of Appeals flipped that decision, creating total legal uncertainty. This basically forced the Supreme Court to step in as the final referee and settle this thing once and for all. To get to the bottom of this, the Supreme Court had to cut through all the legal noise and boil this complex case down to its most essential parts. The court really zeroed in on one legal concept: unfair competition. Now, to prove this, you need to check two very important boxes. First, you have to show a confusing similarity, and second, you have to prove there was an intent to deceive. Let's start with that first element, confusion. The first question the court had to answer was actually pretty straightforward. Would an ordinary person, just a regular customer out shopping, be confused by these two Paperone names? You see, the law actually recognizes two different kinds of confusion. First, there's confusion of goods. That's pretty simple. It's when you literally grab the wrong product off the shelf. But then there's a more subtle kind, confusion of business. This is when you see a product and just assume it's made by or somehow connected to a more famous brand, even if the products themselves aren't exactly the same. So the court decided this was a classic case of confusion of business. They figured that even if customers weren't buying notebooks when they wanted printer paper, they could very easily assume that Paperone Inc. was just part of or somehow affiliated with the big, well-known Paperone brand. So boom, that met the first test. One down, one to go. But just being confusing isn't enough. To win a case of unfair competition, you also have to prove intent. This is often the hardest part, and believe me, this is where the case takes a really crucial turn. I mean, how do you prove what a company was thinking when it picked a name? It's one of the toughest challenges in law. You need clear, hard evidence of bad faith. And in this case, the petitioner had what you might call a smoking gun. Okay, let's break down this timeline because it's so important. As early as January 1999, a company called NAPCO was already importing and selling the petitioner's Paperone products right here in the Philippines. The trademark was filed for just a couple of months later. But here's the kicker. The Respondent company, Paperone Inc., wasn't formed until March 2001, a full 2 years after the original brand was already known in the market. And here is the critical link. The very same people who founded Paperone Inc., people like Tan Siang and Thelma J. Yu, were also the founders of NAPCO, the company that was already importing and selling the petitioner's Paperone products. They weren't just aware of the brand, they had a direct business history with it. The court saw this as clear proof it was no coincidence. The Supreme Court itself drove this point home with a powerful and, let's be honest, very logical question. In their decision, they asked why, with millions of possible names out there, the respondent just happened to choose one that was practically identical to a brand they already knew existed. This right here was the proof of intent the court was looking for. So, with both confusion and intent firmly established, the Supreme Court was finally ready to put an end to this legal roller coaster. The final decision was crystal clear. The Supreme Court overturned the Court of Appeals ruling and brought back the original verdict from the Intellectual Property Office. Paperone Inc. was found guilty of unfair competition. So, what are the key lessons here for anyone managing a brand? This case is a masterclass in protection.
First, a registered corporate name is not a shield against trademark infringement. Second, that whole confusion of business idea is a super powerful legal tool even if your products aren't identical. And finally, courts will dig into your business history to find out who knew what and when to establish bad faith. At the end of the day, being the first to use a mark often carries a ton of weight.
This case proves a name is so much more than just a name. It's goodwill, it's reputation, and it's something worth fighting for. And it leaves you wondering how many other brand battles are out there just waiting for their day in court.